welcome back to this year's last episode of Courts This Week presented by Livelaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from this week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In today's episode, we are going to talk about the criminal law reform bills, the recent legislation that dropped the Chief Justice of India from the Selection Committee appointing election commissioners, the latest development in the 2019 Hyderabad rape murder case, and much more. So let's dive into the headlines. In a pivotal development, President of India Draupadi Murmu has now signed the 3 criminal law reform bills into law, which were passed by the Parliament during the winter session. These bills are the Bharatiya Nyaya Second Sanhita, aiming to replace the Indian Penal Code, the Bharatiya Nagarik Suraksha Second Sanhita, seeking to replace the Code of Criminal Procedure, and the Bharatiya Saksha Second Bill, proposing to replace the Indian Evidence Act. These bills, which had already received clearance from the Lok Sabha on 20th December and the Rajya Sabha on the 21st December, were presented by Union Home Minister Amit Shah. Rajya Sabha Chairman Jagdeep Dhankar in his concluding remarks noted the historical significance of the bills, describing them as liberating the country from the colonial legacy of criminal jurisprudence. The Lok Sabha had previously approved these bills amid the suspension of 141 opposition MPs from both houses. Home Minister Amit Shah defended the bills, stating that they marked a departure from colonial-era criminal laws, shifting the focus from punishment to justice and reformation. He highlighted the legislation's emphasis on digitization, information technology, and the mandatory video recording of search and seizure procedures. However, concerns about potential human rights violations and insufficient safeguards against law enforcement excesses were raised by opposition leaders who were part of the debate. Introduced in the monsoon session, the bills underwent scrutiny by the Home Affairs Standing Committee, which suggested various changes. While some recommendations have been incorporated, others, such as that to provide greater clarity to a provision in the Bharatiya Nagarik Suraksha Sanhita allowing police custody beyond 15 days, or retaining the offence of adultery with gender-neutral modifications, were ignored. At the time of introducing the revised bills, Home Minister Shah clarified that most changes were grammatical in nature. The President of India has also given her assent to the Chief Election Commissioner and other election commissioners' appointment, conditions of service and term of office bill 2023, which was passed by the Parliament in another significant milestone during the winter session. This bill, approved by the Rajya Sabha on 12th December and the Lok Sabha on 21st December, aims at regulating the appointment, conditions of service and tenure of the Chief Election Commissioner and other election commissioners, as well as outlining the Election Commission's functioning. Key provisions of the bill involve the replacement of the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business Act of 1991, which covered aspects such as appointment, salary and removal of the CEC and ECs. The appointment process involves a selection committee comprising the Prime Minister, a Union Cabinet Minister and the Leader of the Opposition or the Leader of the largest opposition party in the Lok Sabha. The committee recommends candidates based on the suggestions of a search committee headed by the Law Minister. The salary and conditions of service for election commissioners were said to be equivalent to that of a cabinet secretary, but after concerns were raised over the pay disparity by former CECs who asserted that the proposed changes downgraded the status of the election commission, the union government introduced an amendment to maintain the salary and perks of the CEC and ECs at the level of a Supreme Court judge. Notably, the bill drops the Chief Justice of India from the selection committee. For more context, in March this year, a constitution bench of the Supreme Court had ruled that the election commissioner shall be selected by a committee comprising the Prime Minister, the Leader of Opposition and the Chief Justice till the Parliament frames a law prescribing the selection process. The bench led by Justice K.M. Joseph passed the direction to ensure the independence of the election commissioners. While moving the motion for the bill's consideration, Law Minister Arjun Ram Meghwal said that the appointment of election commissioners, which was earlier not governed by any specific provision under the law, was an important responsibility of the executive. Justifying the move to remove the Chief Justice from the selection panel, the minister said, and I quote, "This is an important executive function. The architects of our constitution enshrine the separation of powers in Article 50. The executive should do the executive's job, the judiciary should do the judiciary's job, and the legislature should do the legislator's job." Opposition members, however, raised concerns over the Election Commission's independence after the passing of the bill and a potential decrease of the institutional legitimacy in the eyes of the voters. They also raised concerns that this bill was an attempt to overturn the Supreme Court ruling, but the Law Minister defended the legislation, saying that the arrangement proposed by the Supreme Court, that is, a selection committee comprising the Chief Justice, was only a stopgap measure. This week, the Supreme Court Collegium has proposed the appointment of Chief Justices for 5 High Courts, forwarding the names to the Union Government. The recommended appointments are Justice Arun Bhansali, a judge in the Rajasthan High Court, has been suggested for the position of Chief Justice of the Allahabad High Court. The Collegium noted his extensive experience, sound legal acumen and over 1230 reported judgments during his nearly 11-year-long tenure. Justice Vijay Bishnoi, also a judge in the Rajasthan High Court, is recommended as the Chief Justice of the Guwahati High Court. The Collegium highlighted his 652 reported judgments and impeccable professional ethics. Justice Manindra Mohan Srivastav, another judge from the Rajasthan High Court, has been proposed for the role of Chief Justice of the Rajasthan High Court. His tenure of over 14 years includes more than 505 reported judgments. Justice B.R. Sarangi, a judge in the Orissa High Court, has been recommended for the position of Chief Justice of the Jharkhand High Court. With over 10 years of experience and more than 1056 reported judgments, his appointment, among other things, would fill a representation gap of Orissa High Court among High Court Chief Justices. It is also important to note that in the meantime, the Union Government has formally announced the appointment of Justice Sri Chandrasekhar as the acting Chief Justice of the Jharkhand High Court. This notification was issued by the Ministry of Law and Justice this Wednesday in view of Chief Justice Sanjay Kumar Mishra's retirement on 20th December. Lastly, Justice Sheel Nagu, a judge in the Madhya Pradesh High Court, is proposed as the Chief Justice of the Punjab and Haryana High Court. With over 12 years of service and more than 499 reported judgments, he is the senior-most puisne judge in his parent High Court. This is the first set of recommendations approved by the Collegium after Justice Sanjay Kishan Kaul's retirement on 25th December. Justice Kaul retired as the senior-most puisne judge of the Supreme Court. Malayalam actor and BJP leader Suraj Gopi has filed for anticipatory bail in the Kerala High Court in a case where he is accused of misbehaving with a woman reporter. Initially charged under Section 354A1 IPC for sexual harassment, the charge was later modified to Section 354 IPC for assault or criminal force to outrage the modesty of a woman. Gopi contends that media persons surrounded and restricted his movement in a hotel lobby and he was attempting to clear the obstruction caused by the media, including the woman reporter. He argues that he did not use criminal force or assault her and suggests that the woman reporter orchestrated a narrative of sexual harassment. Gopi asserts that he cooperated with the investigating officer and the charges were altered with a malicious motive. He claims that this is a part of a political vendetta as he is rumoured to be the BJP candidate from Thrissur constituency. Gopi emphasizes the serious nature of the allegations, asserting that they were fabricated to tarnish his image, and highlights upcoming personal and political commitments, including his daughter's wedding in January. The actor has also expressed readiness to cooperate with the investigation, deeming custodial interrogation unnecessary. The Telangana High Court has granted permission for the police party involved in the 2019 encounter death of the accused in a rape and murder case in Hyderabad to intervene and be heard during the final hearing of PILs related to the encounter killings. Among the PILs is a plea to set aside the SIT's order and transfer the case to the Central Bureau of Investigation, advocating for a Section 302 IPC case against the police instead of the existing Section 307 IPC charge. While acknowledging that accused individuals typically lack the right to be heard at the pre-registration stage, the court nevertheless allowed the police party to present their stance during the final hearing of the PILs. The court emphasized the importance of fairness and justice in the proceedings, particularly as they are of public interest. For more context, in late 2019, a veterinary doctor was raped and murdered in Hyderabad, leading to the arrest of 4 accused. During the subsequent investigation, when the accused were taken to the crime scene, they allegedly attempted to escape, prompting the police to open fire, resulting in their deaths. The incident stirred public outrage, prompting a special investigation team inquiry, and the Supreme Court directed a commission to examine the encounter's legality. The commission found evidence pointing against the police officials, indicating a fabricated encounter. In a recent ruling, the Telangana High Court has also clarified that Rule 4 of the Quartermaster Rules only entitles a married army officer to accommodation and it doesn't confer a statutory right on the officer's spouse to retain the allotted housing. The decision stemmed from a writ appeal filed by the estranged wife of an army colonel challenging an eviction notice issued by the station commander Hyderabad for the accommodation allotted to her husband. The appellant argued a statutory right under Rule 4 but was rebuffed by the court, which stressed that the rule addresses the officer's entitlement, not the spouse's right to unauthorized possession. The court noted the husband's relocation to a peaceful zone, rendering his entitlement to Hyderabad housing obsolete. The appellant's plea to continue possession despite her husband staying elsewhere was rejected, citing the need for a formal application for allotment. Despite receiving 8 eviction notices, the appellant had continued unauthorized occupancy, prompting the court to instruct her to vacate the premises by December 29, with an extension until January 15, 2024, if she commits to leaving without obstruction. The Andhra Pradesh High Court has issued a directive for the return of Telugu Desam Party member Yashasvi Bodduluri's passport, asserting that the proper procedure outlined in sections 91 and 102 of the Code of Criminal Procedure were not adhered to. Justice B.S. Bhanumati made this ruling in response to a plea filed by Bodduluri against CBCID police officials who seized his passport on 23 December and failed to return it despite multiple requests. The court emphasized that the seizure lacked authorization and did not follow the prescribed procedures, rendering the retention of the passport legally unsustainable. Notably, Bodduluri, an NRI, was arrested at the airport upon his arrival in Hyderabad, and his passport was vital for visa stamping, which was scheduled for 26th December. The court stressed that depriving him of his fundamental right to hold a passport without due process is untenable. The prosecution contended that Bodduluri, accused of defaming the government on social media, was a repeat offender with 2 FIRs registered against him in 2022. However, the court rejected the prosecution's plea for imposing conditions, stating that if violations occurred, the investigating authorities had legal remedies available. Accordingly, the authorities were directed to promptly return Bodduluri's passport. Responding to a habeas corpus plea by a woman in a queer relationship, the Punjab and Haryana High Court has directed the SHO of Panchkula, Haryana to produce her partner, who has allegedly been detained by her family to enforce a forced marriage. Justice Sandeep Modgil emphasized the seriousness of the matter and instructed the state to present the individuals through the station house officer and the respondents, that is the parents of the detainee, on the next hearing, which is scheduled for 4th January. The plea asserts that when the couple expressed their desire to live together, they were reportedly mistreated by the police, who forcefully handed the detainee over to her family. Concerns are raised that the family might coerce her into an unwanted marriage, having already issued threats of harm. In October, while the Supreme Court refrained from granting legal recognition to same-sex marriages, it urged states to eliminate discrimination against queer couples and ensure protection for their right to cohabit. Notably, the Punjab and Haryana High Court has previously granted protection to a lesbian couple, affirming that Article 21 of the Constitution applies to same-sex live-in couples. That wraps up this week's Legal News Roundup. But before I go, I have a little request from the entire livelaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audiovisual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you've subscribed to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das, and I will see you again in the new year.